Good afternoon. I am Lauren Henry, Executive Director of UChicago Alumni and a proud alum of the college. I am thrilled to welcome you to today's special Harper Lecture, The End of Affirmative Action in Higher Education. Harper Lectures provide the alumni community with the opportunity to return to the classroom from wherever they are in the world, continuing our tradition of asking hard questions, dialoguing about critical topics, and pursuing new depths of knowledge and understanding. Thank you for joining us for today's discussion of this historic Supreme Court decision. We would look forward to opening the floor to your questions later in the program. Please feel free to share your questions via the Q&A box at any time. It is now my pleasure to welcome today's moderator, David Strauss. Professor Strauss is the Gerald Ratner Distinguished Service Professor at the Law School. He is also the faculty director of the Jenner and Block Supreme Court and Appellate Clinic. Professor Strauss, thank you so much for being here with us today. I'll now turn the virtual stage over to you.
Lauren, thank you very much. Thank you all for joining us today. Let me first introduce my great colleagues who are with us on this panel, and then just sort of say a couple things to kick off our discussion. I'll go in alphabetical order by last name. Will Baude is Professor of Law and Faculty Director of the Constitutional Law Institute at the Law School. In addition to many important articles on constitutional law and related subjects that he's written, he's a co-editor of the leading case books on in both constitutional law and federal courts. He is a graduate of the college and of Yale Law School. He clerked for the then Judge Michael McConnell, also a graduate of the law school on the 10th Circuit, and for Chief Justice Roberts. Bridget Fahey is assistant professor of law. She joined our faculty in 2020. She teaches constitutional law. She has already published several important innovative articles on American federalism, and she's also a graduate of the college. She went to Yale Law School. She clerked on the District of Columbia Circuit Court of Appeals and for Justice Sonia Sotomayor on the Supreme Court of the United States. Aziz is the Frank and Bernice J. Greenberg Professor of Law. He's a leading scholar of both constitutional law and comparative law. He is currently doing, among other things, important work on threats to democracy here and elsewhere in the world. He was, before he joined the law school, director of the Brennan Center's Liberty and National Security Project. He clerked for Judge Sack on the Second Circuit and for Justice Ruth Bader Ginsburg. Now, our subject is the Supreme Court's recent decision in the case that's called Students for Fair Admissions, which held that the affirmative action programs used by Harvard and the University of North Carolina were unlawful. Let me just give a sketch of where the law was before this decision. It will be only a sketch, a little bit superficial and imprecise, but maybe something to get us going. The law, in fact, had, I think it's fair to say, been pretty stable for nearly 50 years, since 1976, a case called Baude. The deal was that colleges and universities could take race into account in their admissions as part of an effort to achieve student bodies that were diverse. Now, it had to be diversity in several respects, not just race, and it was very clear that universities and colleges could not use quotas or assign numerical weight to minority status. The term the court ultimately settled on was that applicants had to be considered holistically, one by one, but race could be taken into account, among other things, in that consideration. Now, a couple of things about this may be a little bit counterintuitive. I think it's common in sort of general discussions to see affirmative action as a way of overcoming the legacy of discrimination in society, but that was not a permissible objective of affirmative action for universities and colleges. Affirmative action could be used remedially only in very narrow circumstances. The permissible justification was diversity. Also, colleges and universities had to show that there were no race-neutral alternatives that would produce diversity. And it's not entirely clear what that means if you're trying to achieve diversity, how you can achieve it by race-neutral means, but that's what the court said. And related to that, the institution, really the high institution of higher education, really had to justify the degree of diversity it wanted to achieve and why it had to take race into account to the extent it did to achieve that. So you could argue that the court was trying to fit objectives that are by their nature hard to define into a kind of rigorous framework that they did not fit very well. The Supreme Court's decision in Students for Fair Admissions identified those anomalies and really used them as a basis for saying that Harvard's and UNC's programs were unlawful, and in that way left the future of affirmative action in doubt. That's my first question to my colleagues. Our subject is the end of affirmative action ? What's the answer to the question? Is this actually the end, or is there some room left for institutions of higher education to engage in some form of affirmative action still? So let me start with Bridget.
Thanks, David. So as you kind of suggest in the question mark at the end of the event title, there's a lot of ambiguity in this opinion, in addition to a lot of sweeping statement. And I think how some of those ambiguities will be resolved are gonna signal to us what the kind of terrain will look like in the coming months and years and decades. Maybe I'll just highlight a couple of those ambiguities because that will be where a lot of the action is. So the opinion finds that Harvard's approach to using race and race in college admissions and UNC's approach are unconstitutional. But at the end of the Chief Justice's opinion, there's a pregnant suggestion, which is that nothing in the opinion, the Chief Justice says, should be construed to prohibit universities from considering how an applicant discusses her own race in an essay through the admissions process. And in particular, the opinion highlights how an applicant's discussion of how race has affected her life, has affected the things that have inspired her, her desire to take on certain leadership positions, and other qualitative kind of factors that universities are looking for. So I think certainly if a university said, anytime an applicant mentions race in their essay, we're going to stop reading because we are shearing this process of race, that would raise a different constitutional problem of discriminating against applicants on the basis of their race. So race will always be a part of college admissions, and this kind of discussion at the end of the opinion suggests some ways that it might be relevant, but of course it leaves a lot unsaid. So one thing it leaves unsaid is the extent to which universities can invite applicants to reflect on their race explicitly. It leaves unsaid whether universities can provide specific instructions to their admissions officers about how to read essays by applicants that reflect on race, how connected race has to be to the qualitative factors that universities might be considering, and the extent to which universities can kind of reach beyond the set of examples enumerated in the opinion. So that's one set of ambiguities that I think universities will be very curious to see resolved, and I think will require more litigation. Universities will have to test approaches to reading these applications and evaluating the mentions of race in student application essays. A second major ambiguity in the opinion is the extent to which it allows universities to use facially race-neutral policies that either have the goal of diversifying their student bodies or that just will be expected to have an effect on the diversity of the student body. So everything that we've been reading in the Wall Street Journal and the New York Times, eliminating standardized testing, changing legacy admissions, altering how universities think about recruited athletes, all of those changes in policies will have an effect or could be expected to have an effect on the diversity of the student body. And a lot will turn on how universities and educational institutions frame those policies. And I'll just tee up for people who are watching carefully, and I'm sure many, many members of our audience are already kind of alert to this case. There's a case working its way through the lower courts involving Thomas Jefferson High School in Northern Virginia, which is a selective magnet school that has created a facially race neutral admissions plan that departs really significantly from its prior admissions approach, and uses criteria like a minimum GPA, geographic preferences. There's a lottery component, but it has the goal of changing the racial makeup of the Thomas Jefferson class. So it's facially race neutral, but it is trying to confront a problem associated with diversity. So the district court in that case said that's unconstitutional, and the Fourth Circuit said that's constitutional. All of this happened before the Supreme Court case. So we'll be able to watch that case and understand how that's gonna affect admissions going forward. So maybe I'll stop there in the vein of like further laying or unlaying the land, and kick the floor over to my other colleagues.
So Will, what do you think about that? Is the door closed, or are there these openings that Bridget pointed to for universities and colleges to consider the race of individual applicants and maybe to adapt their policies in ways that are not explicitly racial, but aim to improve diversity? Are those doors still open?
So another line in this this very pregnant paragraph at the end of the Chief Justice's opinion is a quotation I think he likes and has used before from an old case called Cummings versus Missouri, that says, "What cannot be done directly cannot be done indirectly. The Constitution deals with substance, not shadows, and the prohibition against racial discrimination is leveled at the thing, not the name." And I predict that's going to be a very important line that's going to frame the court's attitude towards a lot of what comes next. I think that means that attempts to use the kind of application essay workaround are not going to go very far. I mean, I think the court is genuine in saying, look, if somebody has a particularly compelling life story and that, their life and their identity is part of that, that's fine, you can take account of that. But if somebody can show a bunch of similarly situated applicants where people of some races sort of always have compelling life stories and people of other races don't have compelling life stories, I think that's gonna get into a lot of trouble very quickly. I think the race neutral alternatives is a little more complicated. I think, the court has said in the past that, when you're deciding amongst several different race neutral alternatives, you can think about the fact that one will create a disparate impact and the other won't. So in thinking about whether to adopt a new admissions test, the fact that it'll disproportionately disfavor, underrepresented minorities is something that's okay to think about. They might walk back on that in the Thomas Jefferson case, I'm not sure. But I still think they'll also be alert to the question of, are you just trying to reverse engineer the policies we held unlawful? If you come in with new changes to your admissions policy, that seems like there are attempts to do indirectly what cannot be done directly, I suspect the court will have a similarly skeptical attitude. Now, two other doors, maybe they're windows, but two other things that are a little bit open. One is there is a pregnant footnote in the opinion about things like the military service academies and whether they might be the rare case, I think, in the court's view that could pose a real compelling interest different from the one faced in ordinary higher education. Specific stories of a military readiness and the need to have a diverse officer class. I'm genuinely unsure how, whether that's open, but it might be. The court might put the military in a different light, as it often does in these cases, whether it should or shouldn't. And then I think the other big question, which is not one the court wants us to think about, is really just how strong is the court's will to actually enforce this? How much actual scrutiny will there be, of every admissions officer's emails, and how many of them will be deposed, and what kind of enforcement will there be? Or will it be the case that as long as you take the race checkbox off of the common application, and as long as your numbers don't look exactly the same from year to year, will the court say, well, that's good enough and we kind of trust you? Or will there be a ton of depositions and discovery and really sort of going through people's emails? That I think is hard to say. Does the court have the will to try to enforce this if people try to evade it?
So thanks. So Aziz, can you sort this out for us? So are there doors open beyond sort of military exceptionalism, which is, as Will said, the theme we see in several contexts? And if so, how covert does the entry into the door have to be in order to satisfy the court? And as Will said at the end, will the court's not just the Supreme Court, I suppose, but the lower courts really decide that they're going to allow sort of full board litigation about this, but just kind of how do we make sense of all this?
One data point here is the experience of California, which 25 years ago prohibited affirmative action by popular referendum. The experience of California suggests that there are a number of measures that universities can take that do not involve direct consideration of race, but that have the effect of changing the composition, ethnic and racial, of entering classes. Probably the most important of these are increased investments in outreach to geographic communities that are traditionally untapped by a university system. There are a number of empirical studies from Stanford that demonstrate that outreach investments can have disproportionate effects on the racial composition and the ethnic composition and the class composition of incoming university cohorts. Over the course of 25 years, the California system has invested around $500 million in such outreach and recruitment and other efforts. The effect of that investment has not been to bring the California system back to the levels of racial diversity, particularly with respect to African Americans, that were present prior to the prohibition, but it has been to substantially mitigate the initial very large drops in enrollment and entrance of both Black and Hispanic students. I think that the question whether the kind of measures used by a system like California's could be transferable to a broader context or whether they will be transferred to a broader context, doesn't so much depend upon the reading that one has of the SFAA versus Harvard opinion, but rather on the question of whether that opinion is extended. And this picks up on something that Bridget identified. The rule that's applied in SFA v. Harvard is an anti-classification rule. The decision maker, normally the government decision maker when it comes to constitutional law, is not permitted to directly apply a decision-making criteria that concerns race. None of the measures that California have taken plausibly fall afoul of that colorblindness anti-classification rule. Instead, they might be attacked on the basis of a different equal protection theory. That theory would be that the university system in California is pursuing an impermissible goal. It has an impermissible purpose in, for example, extending outreach to communities where previously few people had sent their children to college. The intent theory of a violation of the Equal Protection Clause is the one that's at issue in the Thomas Jefferson case. And I think it is worth observing that the SFA opinion is actually quite carefully written, not to either cast positive or undermine that theory of equal protection violation. So I think that that is a genuinely open question that the SFAA court was careful to steer around.
But just to follow up on that, Aziz, but that would be the issue in the Thomas Jefferson case that Bridget described.
Right. The issue there would be under standard equal protection doctrine, it is impermissible to act with a certain kind of intent. Normally, this is understood as the intent to behave negatively or to proceed on the basis of an adverse assumption with respect to a particular person in relation to their race, ethnicity, or gender. In the Thomas Jefferson case, the argument would be that the intent to elevate or to aid a class because they are members of a particular race violates the Equal Protection Clause. In this regard, the challenge in the Thomas Jefferson case is akin to a series of challenges brought to provisions in the recent fiscal stimulus legislation that channeled funds to African-American farmers who had previously been subject to discrimination. Those provisions were invalidated. And one can imagine that a theory under which those provisions were invalidated might be extended to this case, to the future case that you're asking about, David.
Okay, let me just pick up on that for a second, because this is all very interesting. One position that some opponents of affirmative action take is discrimination. Racial discrimination is racial discrimination. It doesn't matter who's hurt and who's benefited. Racial discrimination, period, is unacceptable. And there are aspects of the opinion in SFFA that use that rhetoric, but I think, as Bridget and Aziz and Will said, it's not the dominant theme. If that were true, if we were operating in a system in which things were to be treated absolutely symmetrically, so if you're asking a question about affirmative action, you could hypothetically say, well, could a segregationist university have used this justification for keeping its classes all white in the 1950s? And if the answer to that is no, then a university cannot use a similar means of keeping its classes diverse. So if a university in some segregationist state in the 1940s or 1950s said, we're redoubling our outreach to all white high schools because, boy, oh boy, we really do not want Black applicants. No one today would think that was okay. That's how we should view outreach to minority schools. I take it, notwithstanding the language and the Chief Justice's opinion about how you can't do things indirectly that you can't do directly. I take it we're not there yet. We're not yet at the point where that's the sort of hypothetical we are to ask about these issues. Will, what do you think?
I think we might be there. I think as you read through, there might be a little bit of a conflict between the rationale of the opinion and its operative language, but the rationale of the opinion is full of this discussion about how, there's only one kind of race discrimination. Eliminating racial discrimination means eliminating all of it. They quote the original opinion in Baude to say, the guarantee of equal protection cannot mean one thing when applied to one individual and something else when applied to a person of another color. If both are not accorded the same protection, then it is not equal. And they find similar threads, going back to the kind of colorblindness motifs of the first Justice Harlan and Strouder and lots of cases. So I think there's a lot in the opinion to suggest that we should be in symmetry land. And I think you're right that if we are in symmetry land, then a lot of these other questions are case closed. Now, the court doesn't connect the dots. It doesn't say, and here's what follows from our symmetric approach. But I think the opinion repeatedly and pretty emphatically suggests that the court's view is that all race discrimination is the same and it's all bad.
So Bridget, symmetry land, so that whenever anyone says, boy, it's such a good thing that our entering class is diverse, we should hear them saying, boy, it's such a good thing that our entering class is all white. That they're basically saying the same thing. Are we in that world now?
I mean, I think this is one of those questions that picks up on something that Will said earlier, which is about whether the court has a kind of institutional appetite to be micromanaging university admissions policies, including how universities talk about their communities and how universities express their institutional purposes. And the opinion includes lots of language of distrust of elite universities, but it feels a little bit more bark than bite to me, because micromanaging how universities, every last thing that a university president or provost or random admissions officer says, puts the court in a position to be hearing affirmative action cases once or twice a term forever. And the court has to decide what its institutional appetite is for that. And it would not surprise me if its appetite for that were not terribly high. That addresses, I think, your question, because I think one of the ways that the court might thread the needle between the strong language in this opinion and a desire to kind of get out of the business of really carefully supervising universities going forward is to maybe bless a template. So in a future lawsuit, a university will come forward with a good faith proposal that is complex and has lots of moving parts. And the university will assess it and say, this is a template that is acceptable. Or maybe it'll say, these three are unacceptable, but here is an acceptable one. And a template embedded in something like that, I think, could be some of these, as Aziz mentioned, investment in underrepresented geographic areas. The Thomas Jefferson plan is interesting in its complexity. It has a lot of different moving components and a lot of hydraulics. And I think if the court blesses a template, then it gets it away from having to weigh in on exactly what kinds of statements by exactly what kinds of people are, disqualifying. So I guess my instinct is that the court will move in that direction. That might end up meaning that the template that the court blesses is like a pretty quite narrow one. But I'm just not sure I see the court having the appetite to hear a feverishly high-profile affirmative action case every term into the future. And these multi-factor tests and scrutinizing complex institutions and how they operate, I think, could be expected to yield that.
Okay, on that subject about just how aggressive the court, I guess all the courts are going to be in policing the boundaries set out by SFFA, whatever exactly those boundaries are. As I read the opinion, and maybe I'm overreading it, there's sort of a undercurrent of deep distrust of universities. I mean, one attitude you could have taken to this whole question is, look, universities are operating in a highly competitive environment. They have to do their jobs of education and research well, or they will lose students, they'll lose faculty, they'll lose donors, they'll lose alumni loyalty. American universities in particular are judged by most accounts, including accounts of non-Americans, the envy of the world. So when a university says, you're asking us to kind of quantify how much diversity we want, we can't do that any more than we can quantify why we want our drama program or our music program, or for that matter, our sports program or our distribution of majors. We can't quantify any of that. That's just not the kind of business we're in. But you should sort of give us some trust that we know what we're doing. The court seemed to have no patience with that, as if they suspect something nefarious is going on. Now, am I overreading it? Am I making too much of a few stray remarks in the outcome of the case? Or is there something like that? And if so, what is it that they think universities, what is the nefarious thing they think universities are doing? Aziz, do you have a view about that?
I don't think this is an explanation for the remarks that you identified, David, but it is, I think, very difficult to read those remarks today without thinking about the Chetty study, the Raj Chetty study that was released yesterday, which demonstrated that of the 15 most elite universities in the United States, including the University of Chicago, the chance of being admitted to the university conditional on having a certain SAT score doubles as one moves from the 99% to the 1%. So one way of reading the skepticism that's in the opinion is as an appeal, perhaps genuinely felt, perhaps not genuinely felt, to a broadly held suspicion that universities operate as social mechanisms for the preservation of economic hierarchies. I think the Chessy study opens up also the possibility, and indeed explicitly invites the possibility, that there are several margins along which universities could alter the nature of their admissions process, which have explicit socioeconomic diversity in mind that would have substantial effects. I think that the lurking unanswered question there would be that, or the lurking unanswered question in the effect, were that to be the rhetorical and practical path that universities take. And indeed, we already have had universities, I believe it was Wesleyan, repudiating the use of legacy preferences, which is the most important factor that the Chessy study identifies. If that's the path that the universities take, I think it will be difficult to challenge that kind of strategy on, let's call it, color consciousness grounds. But I think that the open question will be how those socioeconomically sensitive, class-sensitive reorganizations of the admissions process generate different patterns, not just of economic diversity, but of racial diversity. I'd add just one more thing about the doctrinal question about the doctrinal context that you raised, David. And it's this: in previous opinions, the court had expressed deference to university administrators, particularly a pair of cases about the University of Texas. And one way of reading the language that you cite is as a very conscious effort to reject that element of the doctrine. So the court had to put that in there in order to circumnavigate a prior doctrinal orientation.
Yes, I think that's right, that they had explicitly indicated deference in earlier cases, and this opinion repudiates that. Well, let me pick up with a couple things Aziz said about this. So to the extent there is a kind of ambient distrust of universities in these cases, does it come from this idea that, look, you're really kind of being hypocritical? You pretend you're helping out disadvantaged minorities. That's not really what you're doing. Look at what gets admitted. Legacies get admitted. People, the children of donors, get admitted. They don't talk about athletes in this case, but they have in earlier cases. You know, that's the game you're really playing, as Aziz says, kind of helping out people who don't need help. And there's a suggestion that's true of affirmative action too, that the people who get in are relatively privileged members of minority groups. So do you think, so two parts, I guess, to the question coming out of what Aziz said. Do you think that there is this distrust, that's the source of it? And just sort of let me link that with another question I wanted to get you all's views on, which is, you often hear that if universities really want to do some good, don't give a preference on the basis of race, give it on the basis of socioeconomic status. That would actually do some good. So would that solve both the problem, to the extent it's a problem that affirmative action is supposed to address, and also kind of ameliorate this distrust that universities are pretending to be doing something they're actually not interested in doing?
Yeah, those are, I mean, so let me say a couple things. So I think some of the court's skepticism may come from a sense that universities are asking for special treatment that from the point of view of the courts, they do in the lower federal courts hear a steady diet of cases about race discrimination in ordinary businesses all the time, right? We have to second guess the decision of the manager of the AutoZone to transfer somebody from one shift to a different shift and figure out what was going on there and so on. And so I think it may be also from their point of view, universities are coming in saying, Fortune 500 companies have been complying with all sorts of things for a long time, and we want to have a looser standard. Maybe that's not an accurate picture, but I think the court may feel that way. And the court's saying, no, everybody always thinks the rules don't apply to them, but we think the rules apply to you as much as to anybody else. I suspect the court is also skeptical about whether universities are really making their own individual sort of academic judgments. Like they're skeptical that the president and fellows of Harvard College really sort of independently thought about what kind of school they wanted to have, as opposed to kind of following a general social trend and demand, right? It's a different claim if Harvard is saying, look, we're trying to field the kind of class that our alumni want us to field so that they continue to give us lots of money. It's a different kind of claim than we are expert educators and we have thought about the best way to educate. And even though whether people like it or not, this is what we want to do. And I think the court is kind of suspicious about maybe the whole culture in which universities run and the extent to which they're really engaged in individual thoughtful determinations of pedagogy, which gets us to the sort of the more interesting in some ways questions about economic redistribution. I am sympathetic to the idea that the claim you cited, maybe universities should really focus more on economic diversity and forms of privilege that are not reduced to race, which will of course often pick up race, but not always. That said, there's the majority also points out that already the majority of institutions of higher education in this country don't use race in admissions, right? Many of them, where many people who are less privileged are educated in important ways, are less selective institutions. And so it might be if we really wanted to do good in this country, what we would do is provide much better funding for the community college system throughout the country. And another important success of California's approach, I think, rather than assume that sort of everything has to come from Harvard on down. I realize that may be a self-defeating thing to say to a group of us who all went to the best university in the country, but it might be that we need to share the wealth.
So Bridget, just a couple of things now. I mean, I guess it's three things to think about. One is, maybe the last point Will said, which is, should we think that this whole fracas about affirmative action in university admissions is just kind of a little elite preoccupation? That, yes, it matters a lot to people who are trying to get their kids into the very best schools and they end up going to the second best schools in their minds. But that's not really what higher education in the United States is about. It's about the very many community colleges or four-year colleges that, have more or less open admissions. They will take anyone who applies or at least have very unselective standards. That's where the sort of really important part of American higher education is. Affirmative action is not an issue there. So what you've got is a bunch of overeducated people fighting about something that affects them and their families in actually, in the end, pretty marginal ways, and ignoring this broader context. So I guess is that fair? And then the related question that Will and Aziz picked up, is there a sense in these cases that universities are on some level kind of, elite universities so-called, on some level kind of corrupt, that something's going on here that should not be going on here, and they're pretending these are high-minded educational judgments. They're not really, and that, as much as anything, is animating the court. Do you think those are fair characterizations of what the court's up to? And if they're fair characterizations of what the court is up to, is the court right?
Yeah, I mean, starting with your second point, and with some of Will's reflections, are universities sort of corrupt? It does, as you read through you follow the litigation in these cases and read the briefs and look at the discovery materials, you do notice that, of course, there are aspects of university admissions processes that universities are more eager to advertise than others. And to Will's point about, are these kind of legacy admissions processes just the kind of accretion of changes over time and muddy balancing between the need to finance the university and the desire to do some kind of social good and the desire to and kind of high theory of education, or are they sort of thoughtfully crafted strategies? I think it's true that the court uses that as atmospherics, but I also think it's important to keep in mind the hesitancy I think it's reasonable to have, and even that I think some of the justices in the majority in this case would have, about making the judgment that the federal constitution has a view about what the mission of universities must be and how universities have to justify their missions, that the federal constitution has a view about how universities have to use quote unquote merit as defined by Harvard or as defined by a community college, that there's a federal proscription on these institutions. And I think as this doctrine develops in light of this opinion, I think you'll see some settlement that kind of says, this kind of sense of, I mean, you use the word corruption, this sense of universities being a little bit prevaricating about what they're actually doing might actually give way to, again, to come back to something we talked about at the beginning, a little bit of an institutional anxiety about locating in the Constitution a kind of architecture of what the university is and what it is designed to do, which implicates some of the part of your first question, which is, are we just obsessing over a rule that only affects a few? I think that we will see this opinion very quickly become influential in cases about secondary education, as the Thomas Jefferson case illustrates. I think we'll see the principles articulated in this opinion be present in a whole variety of discrimination-related lawsuits that are outside of universities, elite universities, also, and outside of education entirely. So within, I have been interested to follow the reporting and the studies, some of which Aziz cited, about how different kinds of universities operate. And I think that conversation will continue, but I do think this opinion is not, even though it is in this kind of distinctive educational context and that supplies a lot of the music in the background of the opinion, I think the kinds of the rule the court arrives at and the justifications the court gives for that rule will filter into every aspect of education and non-educational admissions, selection, hiring, etc. So I think the reach will be broad, even though it is in theory kind of about education.
Okay, thanks. I think it's time to move to audience questions. And I've got the first one, which is from someone who took my constitutional law class. So thank you for coming, despite that what must have been terrible experience. And thank you for the question. So here is the question. It's a very good one. I don't know. It must have picked up some common law somewhere else. The question is this: the court's opinion doesn't really engage with the doctrine that the court itself had developed in the series of cases, affirmative action cases, going back nearly 50 years to Baude, which is you need to have a compelling state interest, and the classification has to be, as the court liked to say, narrowly tailored or necessary to achieve that compelling interest. So the question is what we should make of the relative lack of emphasis on that traditional framework. And does that have a bearing on the future, and whether that means more doors will be open, or whether that means the court is really not interested in people using its doctrine to justify affirmative action measures? So what about that? Is it fair to say the court has kind of moved on from its previous doctrinal framework? And if so, what does that suggest about the possibility of affirmative action in the future? Aziz, want to take a crack at that?
I would read the opinion respectfully a little differently from the questioner. The opinion homes in on one element of the established doctrine. This is the idea that the state must be pursuing a compelling state interest or it must cite a compelling state interest as a justification for the use of a racial classification. The court focuses upon the difficulties, which David mentioned in his opening remarks, of defining with precision diversity for the purposes of evaluating whether it is narrowly tailored, and leverages those difficulties to reach the conclusion that diversity, as it has been articulated since Justice Powell's opinion in Baude, is not a plausible, compelling state interest. In my reading, that ruling or that line of logic is within the framework of what's called strict scrutiny doctrine. So the court is not deviating or repudiating that larger doctrinal framework. But it has a number of, to my mind, very interesting implications. Here are two such implications. The first is this: the critique that is made by the SFAA court of diversity could be made of many other interests that are or that have been thought to be compelling state interests. For example, the court refers to a 2005 case where the prevention of violence in prisons was cited as a justification for a race-conscious rule. But many of the same empirical uncertainties, difficulties in measurement, and calibration of the cutoff point for the compelling nature of an interest that arise with respect to diversity also arise with respect to the physical security concern that the court seemed to embrace. Much the same could be said of national security as an interest, one that is conspicuously absent from the opinion, notwithstanding the general consensus that national security would be a compelling state interest. The second observation I'd make in respect to the question is it's worth noting that there is a tension between the logic of SFAA, which is don't accept compelling state interests that are too difficult to define, and the logic of the court in a case called Gill v. Whitford. Gill v. Whitford arises in a different doctrinal posture. It's a case about redistricting, and it holds that the court cannot reach redistricting cases because they are partisan redistricting challenges, because they are what's called a political question. But a key part of the logic of the Gill opinion is the idea that the equal protection challenge to partisan redistricting shouldn't be adjudicated because the court would have to rely upon an expert measure, in fact, one developed by our former colleague, Nick Stephanopoulos, that would be extremely precise. So here we have the court rejecting or embracing an equal protection challenge on the ground that the state's goal is too vague to be measured. And in other contexts, we have the court rejecting, albeit in a different doctrinal frame, equal protection challenges on the ground that the goal is too precisely measurable. It's not quite clear how you add those things up.
Great, thank you. And thanks again for the question, and thanks for joining us to the questioner, my former student. Here's a second question, and it picks up on what a couple of us have mentioned about that footnote, putting military academies in a separate category. And the question is, could that exception for military academies be used by other institutions that want to engage in affirmative action? So the specific question that the questioner asked about was maybe a medical school could say, look, we're kind of like a military academy. We have to train doctors who are going to serve in areas where being of a certain race is critical. I'm paraphrasing the question, but that's the general idea. So the exception shouldn't be limited to military academies. Other institutions might also have a compelling interest, analogous to the military academy's compelling interest in educating a diverse population. So let me ask you, Bridget, and let me put the question this way. Before you joined our faculty, you were a real lawyer. You worked at Wilmer Hale doing great work on a bunch of cases. If you were in that role, and whichever side, either someone using that argument, your client using that argument, or someone using that argument in a way you wanted to oppose, would you see that as a viable argument, that this footnote opened the door to other institutions saying, we're not that different from military academies?
I think my instinct would be, when you're an advocate, you want to press every plausibly viable argument. I think trying to make comparisons to the military is very hard. The military can be seen as exceptional on many different dimensions. I think the question's interesting because it invokes this a justification for diversity that actually I think could probably be measured. This was a justification for diversity pressed in Baude, which concerned the UC Davis Medical School, and one of the justifications that the school put forward is we need to admit a more diverse group of doctors so that group of doctors can serve a more diverse population and in particular go into underserved areas. And the court said that's not an acceptable rationale, in part because the way that Davis put forward that justification was pretty abstract. I think there is now a substantially more study of how a diverse pool of doctors affects health outcomes, especially for minority populations. So if there was, one thing that there might be appetite for among institutions is to attempt to meet the really delicate needle that Aziz laid out in his comments, which is the needle between being too precise on the one hand and being too abstract on the other in what your compelling interest is. This opinion seems to foreclose the idea that there are, as offered now, any compelling governmental interest that can justify the sort of race-conscious admissions that the court sees places like Harvard and UNC using, although that, exactly what those universities do is a little bit of a point of contention between the majority and the dissenting opinions. So, you could see litigation in which institutions press new kinds of interests. And, is the most likely analogy one to the military? Maybe not. You might make that argument, but you might have more success finding the most studied diversity interests that speak directly to outcomes and could produce the kind of manageable standard that the court complains that Harvard and UNC lacked in this case.
Great, thank you. We unfortunately are nearly out of time, so let me just ask one kind of global wrap-up question to my colleagues before we end, which is this. It's an impossible question, of course. 20 years from now, when people look back, will they look back at this decision and say, no, that was a turning point. That really changed the nature of higher education, and to something Bridget said, maybe change the nature of a lot of other institutions that are also bound, if they're public institutions, bound by the same constitutional rule, if they're federally funded, bound by the same rule as Harvard. So that really changed the American society in pretty significant ways. That was a turning point. Or will people look back, and this ties into something Aziz said about the California experience, people look back and say, well, it kind of made things a little more difficult. Things are, university admissions classes, maybe police forces, maybe public sector workforces, they're less diverse than they used to be, maybe less diverse than some people would like, but it's not a huge difference. And basically, between the changes in society and kind of ways that institutions found to deal with the new body of law, that was not a nothing burger, but not a huge development. So 20 years from now, which is the more likely scenario? And you are forbidden to say it's something in between. You can't say that. Of course you can. So which is it? Bridget, you want to take it away?
Yeah, I mean, I think that this will be a moment that is remembered. I think the challenge in assessing that, and obviously I'm not a historian, but is disentangling. There's so much interest even before this opinion, before this litigation, in scrutinizing, in having the public scrutinize how universities conceptualize their communities and do their and structure their admissions processes. So, I think it would be like, looking back, it will be hard to disentangle exactly what this opinion caused and what was preceding apace anyway. I'm especially thinking about the study that Aziz cited that got front page news coverage yesterday about just the extent to which being extremely wealthy is a huge advantage in elite university admissions. That's just the, tip of the iceberg in conversations about socioeconomic diversity on campuses. And many universities, Chicago included, have taken enormous steps to diversify in that respect. So I think this moment will not be forgotten. And I think this case may come to be seen as a kind of stand-in for both the legal and the kind of social forces that are in particular moving to shine a lot of light on socioeconomic diversity in particular.
Great. Will, what does your crystal ball say?
I agree. I mean, so I think it's rare for the court itself to be the one to spur major social change. I think, when the court's decisions really are transformative, that's in part because other institutions react to them in a way that buys into them, or at least takes them in that direction. But if I had to predict, I guess I think that might happen. I think you're already seeing, for example, a lot more scrutiny of things like legacy admissions than I think would have happened without this decision. There's now an investigation against, I think Harvard's legacy admissions programs for the disparate impact that causes by the Department of Education. I think it would not be surprising to see bipartisan legislation in Congress banning legacy admissions, possibly pass, by overwhelming vote if it ever got to the floor. And I think that just could be the beginning of a conversation about sort of, now that we're forced to think again about what are our universities trying to achieve with their class and what are their goals, I wouldn't be surprised actually to see a lot of change that we would ultimately trace back to this decision forcing us to think about it again.
Aziz, so what do you think? I mean, quite possibly a major turning point, although not necessarily attributable to the decision itself, but maybe attributable, at least in part, to the same forces that brought about the decision, or a sort of just a blip, a minor episode.
I think if one steps back and views this in the lens of national politics over the long term, there's good reason for thinking that this is a smaller rather than a larger deal. The first reason for that is if one reviews the social and institutional mechanisms through which outcomes in the life course are allocated unevenly to Blacks and whites in particular, higher education would not rank high on that list. Probably first on that list would be the criminal justice system, a criminal justice system that generates 3 times as many. That means that an African-American man has 3 to 4 times the likelihood of dying in their lifetime in an encounter with the police than a white man. Police deaths, of course, are just the tip of the iceberg when it comes to contact with the criminal justice system, which is disproportionately focused on African-Americans in ways that have concatenating effects upon labor market options, economic outcomes, educational outcomes, and the ability to pass on skills, resources, and wealth to future generations. So in my view, the focus upon universities in particular as mechanisms for the transmission of equality or inequality should take second place to the importance of mechanisms such as the criminal justice system. That's not to say that there won't be changes at the margin from this opinion as a consequence of this opinion that are substantial. Picking up on the last question that was asked and on Bridget's answer, I would focus upon the disparities in maternal and child mortality that are identified across the United States, but in particular on the south side of Chicago. Take a Black and a white woman who are of equal socioeconomic status, equal wealth, equal education, both go into childbirth with equal numbers of comorbidities. The Black woman is 1.6 times as likely to die in childbirth. And we have very good evidence that disparity is reduced by having a Black rather than a white, either nurse, midwife, or physician. So even if this is not an opinion that changes the course of American racial politics more generally, and I don't believe it will be, that's not to say there's not a human toll to the opinion that's identified in the prior question and in Bridget's answer that is not worthy of being attended to.
Thank you, Aziz. Okay, we have to come to a stop. Let me thank my friends and colleagues, Bridget, Will, and Aziz for this discussion, which, I learned from my colleagues all the time, and this event was no exception. And now I have to turn it back over to Lauren for her wrap up.
Thank you so much, Professor Strauss, and to all of our panelists for this insightful conversation. And I want to thank you, our audience, for all of your wonderful questions. We had more than 60, many more that we could cover in just the hour that we had. So thank you so much for coming and engaging so thoughtfully with the topic. I would expect nothing less. I hope that you'll continue to engage with the university and with the alumni community, whether by attending another event, volunteering, providing philanthropic support for faculty and students, or simply spreading the word about the groundbreaking work and thought leadership that's happening at the university. You can learn more about opportunities to do all these things and more on the Alumni and Friends website. The link is in chat. And most importantly, I want to say thank you again to our faculty, and thank you again to all of you for coming together with our University of Chicago community today. Enjoy the rest of your week.